Good morning, everyone, and welcome to our webinar today. We've got a really relevant, very timely, and very important topic, and we've got a fantastic expert guest with us. How can employers reduce the risk of transmission of COVID-19 in the workplace and minimize their liability of exposure in the process? The reality is to reduce the chance of a lawsuit against your business arising from COVID-19. You've got to be prepared. You need to have the right legal documents in place. And so one of the things that we're going to cover today is we are going to talk about how you can prepare yourself as an employer for all the new dynamics in the market. Our guest today is Mr. Ed Cross. Ed Cross, he has been a lawyer for over 25 years. He's a former certified indoor air quality consultant and has devoted a significant portion of his career to legal issues arising from airborne indoor microbial contamination. He represents businesses across the country and drafts contracts to help minimize the liability, and he teaches a variety of risk management programs. He was a contributor to the IICRD mold and water mitigation standard. He is a restoration advocate for the Restoration Industry Association and the founder of Restoration Contract Store at therestorationlawyer.com. So at any time as Ed is just speaking and providing us with guidance, take a moment and head over to therestorationlawyer.com. My name is Leighton Healy. I work with KnowHow. We are a cutting-edge software making it possible for you to equip your entire workforce instantly with processes, procedures, expert step-by-step guidance to ensure that your whole workforce works is in compliance and consistently, and as management is able to know if workforces are moving in the right direction. We have a number of promotional partners to thank just to kind of helping us get the word out about events like this. Ask Amy, Violan Management Associates, Business Mentors, as well as Core Group, and of course Ed and his hardworking team at the Restoration Lawyer. So Ed, without further ado, you are someone who arguably doesn't need much of an introduction in the restoration and construction space. Tell us, what is the current legal landscape right now with COVID-19?
Well, thank you for that question, and thank you very much for the opportunity to be here, Leighton. And I would like to thank KnowHow on behalf of the RIA for your support of our upcoming virtual conference. And if there are cleaning and restoration contractors online right now, I urge you to check out the virtual conference that's coming up online. It's at restorationindustry.org. It's going to be October 6th and October 7th. We're going to be doing a deep dive into issues with Xactimate, as well as third-party consultants. We have representatives of Xactware and representatives of JS Held who are going to be there. It's going to be a historic event. So I thought it was good at this point, now that we're a handful of months into the pandemic, to give people kind of an overview as to what the legal landscape is. There's been a few surprises for the industries. There's been surprises for me as a lawyer. Not surprisingly is that there's been a major slowdown in court activity. A lot of courts are closed for live hearings, but there's not a slowdown in case filings. Lawsuits are being filed just as frequently as they were before the pandemic hit. And there's a lot of COVID-related lawsuits that are being filed every month across the country. And unfortunately, the US is racing toward the grim milestone of 200,000 people dead. Obviously, there's a lot of controversy out there. Did they die from COVID? Did they die with COVID? We're not going to get into that debate today. The point is that the disease has spread around a lot of, massive numbers of people. And there's at least one model that projects that deaths here in the States will top 400,000 by the end of this year. Mm-hmm. So the restoration industry is an essential business. What do you do if you're an essential worker, but you're compelled to go work in a dangerous situation? This is a difficult legal predicament. So your friend Ed has some good news and some bad news for you today. First off is the good news. the insurance industry was wrong when it figured that companies that were involved in disinfection work would be faced with a blitz of lawsuits, and it hasn't happened. I think the risk of an employee passing COVID-19 to a customer is actually worse than the risk of a company failing to do proper coronavirus cleanup. So we've gotten some new laws that have come out, and a lot of employers are unaware of these, and employers are getting sued by their employees. And this is where a lot of the litigation has been, and this is where we're going to be focusing a lot of our attention today. We want to be aware as employers that the federal government has issued a number of important health and safety guidelines for employers to follow. And if the employers don't follow those, and there's an employee who gets sick in the environment, that could prove as a catalyst for a lawsuit that could be really problematic, as if it's not hard enough as it is to run a business during a pandemic, right? Yeah. So some of the guidance requires protective measures in the workplace, like engineering controls and filtration and containment. There are a number of important OSHA record-keeping requirements that we want to keep aware of during the COVID-19 pandemic. There are certain types of COVID incidents which are considered reportable incidents that have to be reported over to OSHA. Very important to keep in mind is some of the new laws that have come out, and one of those is the Families First Coronavirus Response Act, FFCRA. This act requires employers to provide employees with paid sick leave or expanded family leave for a whole different variety of reasons related to COVID-19. And it's not just if the employee is actually sick with COVID-19. Certain employers who are subject of the act have to pay leave if the employee is out because the employee is taking care of someone who has been quarantined, someone who has COVID-19, or a child who's home because the child's school has been closed. So I want to take a step back for a second, talk about three basic types of cases, probably the three biggest types of lawsuits that have been filed related to COVID-19. One is in the insurance context. That's primarily where a company is making a claim to an insurance company for business interruption where they had to close as a result of the pandemic. And the insurance companies are denying a lot of those claims. Another one is in the area of contracts. These are class actions, for example, against airlines. So the airline is saying, we're not going to give you a credit for a flight that you're not going to get on. We'll just give you a refund. And so there's class actions for that. Class actions against gyms regarding memberships, issues with school tuitions, for example. And then there's the big hot spot, which is the area of employment. We have tens of millions of people who are recently unemployed, largely because of this particular pandemic. We've got altered working conditions. We've got social complications regarding the health and safety of the workers. And employees who can only be fired for cause are suing their employers where they allege they were not fired for cause, but because it was actually an economic downturn from COVID-19. So the scenario is the company's revenues are down and they let some people go, and they come up with a pretext, allegedly, and the excuse is, well, no, you were fired for cause, and the employee alleges, no, this is actually because of a downturn in the business, and the cause that you've alleged is not valid, it's not true. So employees are complaining that they are being disciplined for complaining about the lack of personal protective equipment. Employers need to be very careful not to impose discipline for that. There's complaints from employees who have COVID-19, but who are directed to continue working anyway, despite their condition. They want to stay home. And some employers are saying, well, if you're not going to come into work, you've abandoned your position and I'm going to let you go. That's fertile ground for a lawsuit. We're seeing lawsuits for that. We're seeing lawsuits filed when people are not allowed to work because they're being sent home for symptoms they don't believe are from COVID-19. I have seasonal allergies. You're sending me home. And what happens when coworkers get concerned? Hey, John over here is sneezing and coughing. I'm concerned that he has COVID. You need to remove him from the workplace. No, it's seasonal allergies. And the employer's kind of damned if he does and damned if he doesn't.
Yeah.
Whichever way he goes, it's a problem.
So that's, what you just described, as a business owner, as someone who over the years has led and managed all sizes of workforces, some in person, some across multiple locations. That sounds extremely complicated. Could you give us some examples of, you've been alluding to some, but do you have any kind of micro case studies of complications that have arisen, that anything that you've been involved in, or things that we've seen in the news that is a great example of maybe someone who doesn't have an appropriate legal response to this whole situation as an employer?
Yeah, okay. Well, there's lots of employee lawsuits filed not only by the employees, but on behalf of the families of deceased employees. One that hit the news early on was against Walmart. Walmart was sued by the family of a deceased worker in Illinois, and they alleged that Walmart failed to identify and isolate likely COVID positive workers. So we want to ask ourselves, what are we doing to identify and isolate COVID positive workers? And do we have documentation to establish that we've actually done that? All right. The plaintiffs in that case are complaining that Walmart failed to notify that the employees when some of their coworkers had symptoms of the virus and they weren't controlling the environment and giving PPE and that sort of thing. There's a case I just got a report on. This one is pending in the state of Ohio. And this is the wife of a deceased employee who worked as a nurse in a mental health facility. And the complaint is that the facility failed or refused to follow the COVID-19 directives that were issued by the state. And a lot of employers aren't following these directives. They're not keeping up to date on what the latest directives are, and they're changing. The directives you had, last week aren't necessarily the ones that are applicable this week. And the complaint alleges that this woman's husband was exposed to COVID-19 as a result of the company's failure to take those directives, and that they were negligent. And what they're doing, they're trying to get around the exclusive remedy of workers' compensation by claiming that the acts of the employer were wanton and willful. And sometimes we get into a false sense of security thinking that workers' compensation is always going to protect us from work-related illnesses or transmission of the virus in the workplace. That's not true. There's different exceptions that can apply. In some cases, it's really a long shot, and the rules vary depending on what state you're in. But we should not feel like, okay, we're totally protected by workers' comp, because we're not. There's another case I'll touch on just for a second. This one was in New Jersey. It's also a wrongful death case, also filed by a wife who says that her husband was exposed to COVID-19 when he embraced a coworker who later tested positive for COVID-19. She sued the employer for this. And the husband who died was not wearing a mask. Why? Because the employer allegedly instructed workers at safety meetings not to wear masks unless they were performing their specific job functions. And I don't know about you, but when I've been out at businesses and restaurants or whatever, I'm seeing employees who are wearing masks when they're behind the counter, making my burrito. But when they go to take a break, they go and sit at one of the tables out on the patio, and you got 4 employees together. They rip off the mask. You can't eat when you're wearing a mask, obviously. Yeah. And they're 3 feet away from each other, and they're talking and talking and talking. So employers need to get organized and develop a system and show their employees that they're really serious about this. Not only does this help to minimize the liability exposure, but what this also does, most importantly, is helps to limit the transmission of the illness in the workplace. Because if your workers aren't healthy, your business isn't healthy. And it's massively disruptive to a business to have one of these outbreaks. And there's some simple steps we can take to try to control that and mitigate that problem.
And, Ed, all of that really, it transitions well to the second half of this conversation, where just kind of a preview to everyone participating. We are going to get into some, practical step-by-step actions that you could take, and not to let the cat out of the bag, but Ed has really labored over a resource that he's prepared to be able to provide you with guidance. But I just want to remind everybody that if you're paying attention today and you're thinking, I have some questions, we have allotted some time at the end of the webinar for some Q&A. And so within the live stream, there's a chat window. Feel free to start, placing your questions in there. I know that sometimes, questions related to legal things really require kind of a one-to-one conversation. And so sometimes it just means that we need to connect you with Ed or someone from his team. But throw those questions in there so that we can come back to those towards the second half of the conversation. So Ed, another thing that I think is something you alluded to, but I wonder if you could just take maybe just a minute to unpack, is that just the state of insurance claims with in regards to COVID specifically. I wonder if you could maybe just provide a little bit more color on that.
Sure. Well, unfortunately, I have it from some very reliable sources that a lot of insurance companies are denying claims, even though they know they have liability, simply because they believe they can get away with it. Mm-hmm. And this is amoral. Okay, it's a horrible state of affairs that they're taking that kind of approach. And if they sit down and they crunch the numbers, they realize they're probably going to make more money. If they do it that way, they're going to get burned a few times on it. But policyholders really need to unite on that sort of thing. So as I mentioned before, a lot of companies have made business interruption claims, and insurance companies are taking the position on those that COVID-19 is not property damage. And if there's not property damage, they're claiming that they don't have liability for that. So that's something that's going to get hashed out in the courts. If COVID contamination isn't damage to a property, I don't know what is. Mold contamination is damage to a property. But we hope that the insurance companies will do the right thing with that. Many businesses are falsely assuming that just because they have liability coverage, if a customer alleges transmission of COVID from one of your employees, that you're going to be covered for that. But what we've learned, very surprisingly, is that a lot of insurance companies are going to take the position that they do not have liability to pay out on COVID-related claims unless the business is actually engaged in the industry of disinfecting buildings. And so we run into this question of whether or not there's an exclusion in the policy for viruses, communicable diseases, or contagious illness. And if there's an explicit exclusion there, and there isn't an endorsement to cover it, like with a pollution endorsement or whatever, that creates an insurance problem. But if the policy is silent on that, there's a very good argument. And I think the insurance companies recognize they have liability to pay on these sorts of things. And a lot of them don't plan to do that. So that's that piece of it. And then the other important insurance issue that we want to talk about a little bit more is workers' compensation. And as people know, as a general rule, most work-related illnesses and injury claims go through the workers' compensation system. And that's designed to guarantee employees or their estates a recovery where there was an injury that's related to the employment. And a lot of states are being very liberal in how they are interpreting whether or not COVID is related to an employment. And it doesn't necessarily mean in every state that they contracted it at your place of business. Right? So what we have to watch out for is the various exceptions that apply to workers' compensation. And this is what the plaintiff's lawyers are going to use to try to assert a direct civil claim for damages in court against the employers to get around workers' compensation. One of these exceptions is called the intentional wrong exception. And the standard for this exception varies from state to state. Now, in states like New York, to get around workers' comp there, you actually have to prove that the employer engaged in acts with the desire to bring about the consequences of the act. But in other states, it's a lot more liberal than that. For example, in New Jersey, the employee merely has to prove that there's a substantial certainty that injury or death would result as a result of the employer's conduct, and that the circumstances where the injury occurred were not an ordinary fact of industrial life. And, contracted COVID-19 arguably is not an ordinary fact of industrial life. So these exceptions can apply. What we're talking about today is general information. Obviously, it's not specific to anybody's particular legal situation. When you've got a specific situation, you need to talk to a qualified lawyer in your jurisdiction about that.
So, Ed, maybe before we jump into, I suppose, some guidance on this, I mean, maybe let me take a moment to try to paraphrase this, and you tell me if I've kind of captured this. So many of our participants today, probably most, are employers or they're decision makers in organizations. And what you've described is that as workforces return to the workplace, there is a potential significant challenge that some of us aren't giving full consideration to, which is that, I mean, it's multifaceted. Staff have concerns about, is the workplace safe? They look to their colleagues and they say, I don't know the contact, history of these individuals. And individuals, when they leave work, they go home, they say, am I bringing anything into my home that I may have been exposed to? So there's all these angles. And I think that the one thing that really is present for me, two things come to mind. And I'd like to get your perspective. One is, regardless of what you think about the pandemic, regardless of what side of, say, the maybe even the political spectrum you fall on, a lawsuit doesn't care, and the courts don't care. At the end of the day, it's what can be presented, what can be defended, and what can be won or defended against in court. And so I really think that if I was to put myself in the shoes of a participant today, what's probably going through my mind is, okay, you've alerted me to something I haven't been totally, maybe I haven't prioritized. How do I get ahead of this thing? And one of the things that, Ed, you have really worked hard to prepare is a crash course that is available on your website. I believe that you called it the COVID-19 Employer Protection Crash Course. So if we were to take 10 to 15 minutes and you gave us maybe the cliff notes of that course, just as maybe a teaser, And then certainly if we want more information, we can go to your website. Take us through that.
Yeah, okay. So one of the goals, obviously, is to give employers a good kind of basic understanding as to the general categories of law that they need to be familiar with that could subject them to lawsuits or other types of legal trouble, whether it be with OSHA or the Wage and Hour Division of the Department of Labor, an agency that does not have much of a sense of humor, let me tell you, and to give you an overview of the different kinds of notices and other material that you want to provide. And we don't want to end up, for example,
take us through that.
The way that Amazon did. So one of the goals, obviously, is to give employers allegedly lackadaisical response to COVID-19 general categories of law. Their workers began to ring safety alarm bells, complaining about overcrowded centers and a lack of protective gear, and the Wage and Hour. There's allegations that they for it, to give you an overview of the different kinds of employees who spoke out about poor safety conditions would face prompt termination. So we need to be extremely careful about this. And kind of the moral to the story is that corporate planning during a pandemic should not be reactionary. It should be proactive. And so what I've developed is a package that includes a couple of things. It includes videos in which I summarize these basic points, what you need to know, and introductions to the employees who spoke out about safety conditions and the FFCRA termination. This is not intended as a substitute. We need to be extremely careful about a bunch of the attorneys' kind of the moral to the story is, and because it's general information, planning it's going to give you a leg up in the event that you consult with a lawyer. So you're going to have some more specific questions is in mind is a package. You're going to include a couple of workings of a plan, videos to help protect in which your workers and minimize the transmission points, the spread within the workplace, as opposed to going into a lawyer's office completely cold and asking the lawyer to create documents from scratch. So I give you an introduction to the major areas of law in a number of videos. There's an ebook that's included with it. And another part of it that's very important is what I call the Employer COVID-19 Protection Agreement. This is a simple one-page document that employees sign. And why is this important? If you were to get served with a lawsuit today, would you have documentation anywhere in your personnel files or anywhere in your office that says that you ordered your employees to stay home if they're sick, that they signed something where they agreed, I'm going to stay home if I'm sick, I'm going to follow the company's protocols for PPE and for social distancing? Do you have a written commitment from your employees that they're going to report COVID-related symptoms to you, that they're going to report to you if they've been exposed to somebody who is suspected of having COVID-19? Are they cooperating with your guidelines? Can you prove that you actually gave them these rules with a signed document? So we created this agreement for them to sign. It's kind of like a pact between the employee and the employer where they're going to work together to try to minimize the spread of the disease within the workplace. Do not fire an employee who's out sick when they're complaining of COVID or they're taking care of somebody because of COVID. Talk to a lawyer before you do that. It could end you up with a lot of hot water. So we provide instructions as to how to fill out this employee form, and there's video that goes along with that. And then we give you a bunch of free forms and we give you a bunch of free links that explain to you the places where you can find your state's current, up-to-date requirements for health screening. Are you allowed to ask about symptoms? Are you allowed to do a temperature check? Are you supposed to do those things? What's your requirement? Not 3 weeks ago or a month ago, but right now, today, we give you an access point for that. We give you an access point for your state's current mask requirements. And then we give you a whole bunch of free miscellaneous OSHA and CDC forms that I compile after many, many hours of research, figuring out what's going to be the most important. There's checklists, there's investigative reports, and there's back to work toolkits that come along with it. And it's really cheap insurance to do something like this.
So I'm just making some notes here, Ed. So I mean, the first thing I'm hearing is arm yourself with knowledge more than anything. Like absolutely, situations always have gray areas, and so there's participants will have to consult a legal provider for some of the maybe more of the gray areas, but ultimately having a broad understanding of the state of the situation, what are some of the potential risks, what are some existing examples of situations in which employers really got broadsided by some of the implications of not being prepared. And then a big part of what you're emphasizing is arm yourself with an agreement that every single worker signs, and you provide a really fantastic template that they can use for that. And then another thing that you talked about is, save yourself all this online searching, and because you're also providing links to all of the websites that a person needs to navigate to be able to get that information. So I'm curious, one of the questions as we were chatting that came in, and if we could just field one question that's related to something you said earlier, when a worker reports that they've tested positive for COVID, is that something that an employer is required to report to OSHA? Are you aware of that?
Yeah, so there's different particulars on that. We get into that in the crash course, and it depends on a number of different circumstances. And if you're not clear on it, contact a lawyer about that. It's not 100% of the time, but it's a very, very important issue. And if you don't comply with the OSHA rules on it, that could be grounds for employees to claim that you're negligent and you're not following the rules, and it's another source of liability exposure.
Hmm. So before we kind of move on to a couple other topics here, Ed. So when a person is thinking about protecting themselves as an employer, other than arming themselves with the information, attending an event like this, going and grabbing hold of an online resource like yours, creating an agreement for staff to sign. What are some other examples of things that a proactive employer should be doing perhaps over the next week or two to make sure that they are protected? They've got a good moat of defense against some of these liabilities.
Yeah, well, I think the main point again is to really take active, consistent steps to minimize the transmission in the workplace and make sure that people aren't breathing all over each other. Come up with a specific system following your state's rules for touchless temperature screening, for health screening. You can't ask all medical questions. All right, there's some that you can ask and some that you can't ask. Fortunately, the CDC has relaxed a lot of those rules. You want to keep documentation of this because, if you get sued and somebody says, hey, what evidence do you have of what your worker's temperature was on September 9, 2020? when he, exposed me. And it's like, well, we let people know that they should tell us if they're feeling sick. Well, the fact of the matter is people are suffering from pandemic fatigue. I mean, we're months into this. They're burned out on the thing. They, a lot of them have cabin fever. They're sick of wearing masks. I'm sick of wearing a mask. And they're getting a little bit lax. And companies assume that, well, months ago, we told our employees to let us know if you're sick, to stay home if you're not feeling well, and then they never mention it again. Well, as time goes by, people take that less and less seriously. But what we find is if you have them sign a written agreement, they do take it a lot more seriously. But the other important answer to your question is to be more watchful and vigilant in the workplace, like, for example, on break times, and really make sure that people are not breathing each other's air, that they're staying away, that they're keeping a safe distance. And one thing that's being developed now is staggered break times. And impress upon your employees that even though the rule is to, let's say, wear masks and socially distance while you're on the job, you need to remember that the virus doesn't take a break when you're on a lunch break. The virus is still there, and keep your distance from people and play it safe. When in doubt, err on the side of caution.
Yeah. It's interesting. There's a leadership principle that I'm sure we've all heard in some form or another, which is that a common mistake that employers and managers make is trying to be liked as opposed to being respected. Trying to be liked instead of creating structure and order in the workplace. And there's probably a lot of people where they have to be maybe they're saying, man, I'm going to have to be a bit of a taskmaster. I'm going to have to really hold the line on these things. But at the end of the day, I think one thing you alluded to earlier in the talk, which I think is just really relevant for that comment, is that an employer doesn't always consider the fact that a big part of having a healthy workforce is them feeling confident that their employer takes us seriously.
Right.
And so how are you communicating to your workforce in such a way that you're giving them confidence that my boss takes this seriously? I think we can probably say that if the manager should be taking it an order of magnitude more seriously than a worker. I've heard somewhere that, if you want a frontline worker to do something at, say, 80% compliance, leadership has to model it and communicate it at like 150% compliance, and then management at, say, 120, and then middle management at, say, hopefully 90, for a frontline worker to do 70. But if leadership is kind of haphazard, loosey-goosey about it, and they're really only being kind of semi-compliant, someone sees them go out to the break room, go out to the parking lot, and immediately, leadership break every policy that they put in place.
Right.
Monkey see, monkey do, right?
Yeah, they're leading by example. I agree 100% with the point that you're making. And as a small business owner myself, the thing I really don't want to have happen is for my employees to be concerned or preoccupied with this topic. And I 100% guarantee that in every state in the union and all over Canada and anywhere else that people are watching this right now, there are employees in businesses who are distracted from their work and not 100% focused because they're concerned that the guy down the hall or the gal at the next desk is coughing and sneezing, and I don't want to create a problem. I don't want to make any waves. I don't want my coworker to get upset with me. I don't want my employer to think that I'm being a pain in the butt, and sometimes they contain it. They're people are really more concerned about this than they let on. And there's a lot of criticism that's happened in the media. We've had altercations in stores that have gotten violent. People are, wear a mask, don't wear a mask. Okay, put up your dukes. Let's have a fight over it. I mean, things are totally out of control here. And I think because of that, people are a little bit more constrained in what they're talking about. And
Mhm.
so we don't want employees to have that level of concern. And if you present a document to them that says, these are the company rules, thou
Yeah.
shalt stay home if thou is sick. And I
Yeah.
think it's going to help them relax a little bit more, saying, okay, the boss has this under control.
So let me, one of the things that just really just jumped out is, as you were describing that, is, if I am a worker and things are unclear in the workplace, I was just thinking that, I could be COVID positive, but because my employer hasn't really made it clear as to how I don't end up on the curb, I might even come to work and hide it.
Right.
Does that make sense?
Absolutely.
We've all heard about asymptomatic cases and things like that. So obviously we can't get into that. But it sounds like what you're describing it is that if you do the hard work of making things clear, even because they will, but even when they sound firm and rigid, in the rare event that a worker does test positive, at least they know that they tested positive in an organization that has structure and order and a way of dealing with that, so they won't get ground up in
Yeah.
the abstraction of a poorly organized workplace. Is that fair?
Yeah, I completely agree. And now the federal government has gone a step further and is requiring employers to give a written notice to the employees about some of these basic rules, how paid leave works, when they're able to go, when they're able to stay. And you know what? 100% guarantee you that there are thousands of companies across the country that are totally unaware of these rules. They're not being informed of them by some of the major payroll companies whose names will remain absent from this presentation. And they just don't know, hey, I'm required to give this notice to notify my employee when they're allowed to be out and when I'm required to pay them leave. And if you don't give them that notice, there's serious legal and financial ramifications for that. But more importantly, again, it just goes back to keeping your people healthy, because if your people aren't healthy, your business isn't healthy.
So, Ed, I want to go to a couple questions. One question was, some of the listeners just had a little bit of audio challenges. And one of the questions that came in is whether you could just take a moment and just provide a bit of a Cliff Note summary once again of the ebook that's on your website, therestorationlawyer.com.
So the book is part of our employers COVID-19 protection crash course, and that includes videos that I created to break down the fundamental areas of law so that you understand, you have a beginning working understanding that you can use to help develop a plan. You get an overview of what CDC expects, of what OSHA expects, of what EEOC expects. We talk about privacy rules when it comes to collecting information. We give you access points so you can find out what the state law allows and requires in your state for personal protective equipment, for masks, what the state requires you to do in terms of health screenings and temperature screenings of your employees. And then it includes an employee COVID-19 protection agreement where they agree to a whole bunch of different terms designed to minimize the transmission of the disease in the workplace, including they commit in writing to stay home if they're sick, to attend company safety meetings, and to be attentive, to follow their supervisor's instructions regarding the use of PPE, to report if they've been around people who are COVID positive, that they are acknowledging the risk of being exposed to COVID in the workplace. One of the other exceptions to workers' comp that we didn't mention before was when an employee alleges that the employer fraudulently concealed conditions in the workplace that may have exacerbated an employee's illness Okay, this could potentially be used as an argument to avoid workers' compensation, sue the employer directly in civil court for monetary damages. We explain all that in the course, and we give you a bunch of free miscellaneous documents, including this notice that you need to give out according to the new federal law, and a bunch of CDC and OSHA documents.
Thanks for taking us through that again, Ed. So we've got a little under 15 minutes before we break today. There's been some new questions that have come up from participants as well. Is certainly one of the things that I was hoping we could cover is just some quick guidance on those providing cleaning services, restorers and cleaners providing COVID cleaning services as well. I know that you're also very involved with the Restoration Industry Association's Advocacy and Government Affairs Committee, so it would be great to get an update on that. But now, I know that in the legal world, there's very little that's just black and white. There's always gray. But a couple of specific questions that came in. One question from a viewer said, if I have an employee who just refuses to wear a mask, even when it's required, should I just tell them to leave the job site?
I think in many cases, if you don't do that, you're going to be subject to legal exposure that you don't want to face. But what you have to do is you've got to see the mask requirements today for your specific state, because there's different requirements state by state, and you have to comply with those. And our crash course gives you a link where you can find and monitor day by day updated lists of those particular requirements. But when in doubt, err on the side of caution and keep space between people.
So what I'm hearing from that, just to summarize that for our viewer, great advice is, first and foremost, the best thing, I always like to tell my teams that, going forward, I know this isn't how we did it yesterday, but going forward, everyone's going to sign this document that clearly outlines what our expectations are in the workplace.
Right.
One is that, and I think a great point is in your resource, Ed, there's a link to my state's requirements of what that mask needs to be. And so that allows me to say, okay, we expect you to wear, this mask, and going forward, when you show up on the job site tomorrow, this is what we require. And so it sounds like what you're saying is that if the expectation is set, ideally that document is in place, then you should in fact tell them to go home because they're not meeting the job site requirements. No different than if you required them to, let's say, wear steel toe boots to the work site.
Okay, I'm not saying send them home without pay.
Okay, good.
And in this environment, anytime there is a COVID-19 related issue with sending somebody home or their pay, you absolutely want to consult with a qualified labor lawyer in your jurisdiction to come up with a good strategy to deal with that, because these backlashes are pretty severe. And ladies and gentlemen, if I leave you with only one point today, it's this: the law is very pro-employee. And some of the biggest verdicts that come out of courts for punitive damages are on employee lawsuits against employers, wrongful termination, constructive discharge. An employee can accuse you of wrongfully firing them, even if you haven't actually literally fired them. If you have made the environment allegedly into something where it's as if they have been fired, like there's no job left, they can sue you for constructive termination. And the way they do that in this context is they say, you're not sending home these people who are coughing and sneezing. I could lose my life by coming to work. It's as if you fired me. That's wrongful. You haven't followed the CDC recommendations to tell these people to stay home, okay? Right. And that's a violation of public policy, and therefore you owe me a big bucket of money for that. Yeah. So it's not that hard to avoid these things, but you need to have a basic understanding of what the legal issues are. And they're new. There's new rules that are developed just for COVID-19, and we need to be sensitive to them.
Going back to something that we had just talked about just a moment ago is the need to install this document, this employer protection agreement. What if a worker just refuses to sign that liability release?
It's not a liability release, first.
Okay.
Workers' compensation generally provides protection and coverage and a recovery for workers who are made sick in the workplace. And if you do ask for a liability release for work-related injuries, that's a violation of public policy, and you can get sued for that. All right. This document is an agreement that the employee is going to stay home if they're sick. They're going to comply with company rules, and they're going to report relevant information to you. They're going to submit to the required health screenings, and they're going to tell you if they've been around somebody who's been sick. All right. If you don't mandate that they sign it, okay, you are setting a precedent with your other employees that they can refuse to sign it as well. But they're not giving up anything, in my view, by signing this agreement, because it's not a release of any rights. It's saying, right, I understand what the company rules are. And so if somebody's not following that and somebody does refuse to sign that, and that person brings COVID into the workplace and gets somebody else sick, hey, you didn't follow your own procedures. And so I would be very firm with them and say, you need to sign this, but hesitate to terminate their employment without consultation with the qualified labor lawyers.
And what I'm hearing is, it sounds like it's no different than in another scenario. You might say, you can't smoke a cigarette when you're working the grill. You can't show up to work with no shirt on. You're saying, if you wake up and you have these symptoms, don't come to work.
Right.
If you come to work, you got to wear this thing on your face.
Right. I mean, employers are entitled to discharge employees who refuse to follow company rules, provided they're doing it, they're discharging the employee for a reason that does not violate public policy or breach a contract that they have with that particular employee, and that almost never applies.
So Ed, we could almost talk about we could spend an entire discussion just about this next question, but what would be just a very short overview of things that cleaning contractors should be aware of when they're actually doing COVID disinfection work? And perhaps, I know that our time is almost gone, so where can a person get more information with that?
Yeah. Okay. So companies that are doing disinfection want to have waivers of liability and releases, because they, in most cases, can't guarantee that they're going to be able to remove all the coronavirus from the property. And so when you execute a waiver or a release, it needs to be conspicuous. It needs to give the releasing party some fairly detailed explanation so that a reasonable person can understand the nature of the rights that they're giving up. All right, it needs to be understandable. So if they choose to read it, and hopefully they do, that they've really made an informed decision about what they've chosen to give up. And the restorationlawyer.com, we've got contracts that are designed for coronavirus cleanup and disinfection work, and they're customized for a bunch of different states. But I've got some good news for the restoration industry. I'm not seeing lawsuits against restorers and cleaners for failing to properly clean up buildings. And you need to keep in mind that on the other hand, when somebody goes into court, they do not need to prove to 100% certainty that they got sick because of one particular COVID exposure. This applies to all employers as well. Some people have a false sense of security saying, well, you can't prove exactly where you picked up COVID because it's all over the place. That's true scientifically, but in court, all you have to do is show you probably incurred the illness as a result of some particular exposure. The burden of proof is actually much lower than people presume.
So that's yeah, that's a lot of compressed information, and so thanks for taking a moment and summarizing that. And you know, and hey, I know we've said it a few times, but I would just encourage the viewers that you know, there's a lot of great materials on the restorationlawyer.com. And Ed, one of the questions that we won't get to unfortunately today, but you're doing a lot of very good work with the Restoration Industry Association.org. And specifically, you're involved in the Advocacy and Government Affairs Committee. So maybe could you give us just like a 30-second clip on, you know, why is that important work, and what are some things that we might just, you know, see coming from that?
The committee seeks to level the playing field legally and financially for restoration contractors who've been under siege from a number of stakeholders in the restoration ecosystem. And we've got a great team assembled, and we've accomplished a lot of wonderful things. And very soon, we're going to be releasing our scorecard, which is a rating system of third-party administrators, TPAs. You're going to see them scored. We had over nearly 1,000 restorers who submitted surveys for that. We've got a very robust set of position statements coming out that restorers can use when they're dealing with third-party consultants like bill reviewers and independent adjusters. And we're going to have some position papers coming out on pricing, and then coming out very soon, October 6th and October 7th is our virtual conference. Online, you can sign up for at restorationindustry.org, and to get our position papers and to get the TPA scorecard, you need to be an RIA member, and it's a very, very worthwhile investment. You get a great return on that investment. I look forward to seeing everybody October 6th and October 7th for a big virtual conference.
Well, thanks very much to our expert presenter, Ed Cross from the restorationlawyer.com. If anything here really stuck with you, I would say your first order of action is to go to the restorationlawyer.com, where that digital resource is waiting for you. I want to take a moment right now and thank all of our participating promotional partners, the team at Ask Amy, the team at Viola Management Associates, the team at Business Mentors, and the team at Core Group, as well as Ed and his team at the Restoration Lawyer. So one of the things that that is available to you is a very detailed resource that includes videos and documents. All of the web-based search work has been done by Ed and his team, and it's waiting for you there. And when you're there, what you'll also discover is that we have collaborated with Ed to also be able to support all of the processes and procedures, just those step-by-step things that you want to have at the fingertips of your staff that kind of work closely with what Ed and his team have developed. So thanks for your time, and we hope that you got a lot of value out of this presentation. Ed, any final words before we wrap up here?
Yeah, I know we've hit people with a lot of detail today, and I think what I should say is learn the fundamentals, understand the basics of these different areas of law, because once you do, you're going to be able to understand and absorb kind of the spirit of it and what the legislators were trying to achieve. That's going to help you develop good instincts and give you the basic building blocks to start to put together a solid plan to protect your employees and protect your business in the process. So good luck to everybody, and keep your people safe.
Thanks, Ed, and have a great day, everyone.